So, Zikhona, thank you very much for agreeing to meet with me today. So, ladies and gentlemen, Zikhona Ndlebe is a brilliant and a phenomenal person. She's a lawyer, practicing and specializing in labor law, and she's also a researcher. So, today we are tackling some labor issues in South Africa, and I bet you guys it's going to be fire. So please stay tuned and listen to the whole interview. So, Zikhona, welcome.
Thank you so much. Thank you, Jacob, for having me.
Right,
really appreciate it.
Thank you. So, every great story has a beginning. So let's start with yours. So please tell me a little bit more about yourself.
Well, beginning is that I'm born and bred in Cape Town, but I'm originally from the Eastern Cape, so that's where my origins are. I studied LLB at UWC, and I completed my LLB in 2015. That's when I started my articles of clerkship at one of the prestigious law firms in Cape Town. And after getting admitted as an attorney in 2017, I started practicing as an associate, and I specialized in labor law. So that is where I'm at. I'm a labor lawyer, and I'm also a researcher, as you've said.
All right. I almost ask you, do you do work for free? But I won't go into that. So, like you said, you studied law at UWC, and you choose a career in labor law. But I know, also being from UWC, so many choose a career in labor law. So, what inspired your decision to do labor law?
I think to answer your question, we need to frame it broadly. What inspired me to study law to begin with? And the inspiration came from wanting to be of assistance to those who are in need of legal services, and also providing legal services with care and due diligence, because I've witnessed in the past where people need assistance, labor-related matters, but they do not have enough funds to get an attorney to assist them with their matters. So I wanted to be of assistance to those people and to also add value to them. But that is also not to say that I provide free legal assistance. But whenever a person comes to me, whether they have money or not, whatever advice I give to them, I make sure that I give advice with care and due diligence, and put my all in whatever I say to a person who needs assistance. So the inspiration was me wanting to be of assistance to those who are in need of legal services.
Right. So you mentioned prestigious law firm. So you didn't name drop. So name drop. Which law firm did you or did your articles with?
I did my articles with Harold Gee Attorneys. It's a law firm that is based here in Cape Town. And I also have to say that one of the persons who inspired me to continue and stay on the path of labor law was the director that I worked under as an associate, and also I worked with him as a candidate attorney, and that is Richard Brown, and he has been in the legal practice specializing in labor law for so many years, and he provided me with so much knowledge, and he inspired me a lot. I've never said this before, and if he ever watches this, he should know that I'm really grateful and thankful for him letting me do the work and allowing me the space to learn, So, yeah.
All right, thank you. So now you've finished, admitted, you're a lawyer of, admitted in Cape Town or Bellville?
Cape Town.
Why laughing? Bellville is just as good. The Bellville also have a high court.
The high court is in Cape Town, so it's Cape Town.
Oh, so Bellville is a magistrate court.
It is a magistrate's court.
Oh.
Yeah.
Okay. So on that note, shade note on the Bellville courts. Let's talk about labor issues in South Africa. So from your experience,
yes,
what are some of the most common labor issues?
So the most common labor issues that I've come across, and I often come across, it's unfair dismissals. And it's mostly dismissals where there are no valid reasons, substance is not there for the dismissal, or a fair procedure was not followed prior to the dismissal. And so that is one of the most cases that I deal with. And then I also deal with retrenchments, where employers don't follow proper procedure prior to retrenching employees. So those are the two main issues that I come across. And I deal with these issues at the CCMA, bargaining councils where applicable, and the labor court.
Okay, so what do you call this thing? Unfair dismissals. So before we unpack unfair dismissals and go a little bit deeper into it, I want to kind of put a theory out there that most labor issues arise from the desperation of people. So they're desperate to get a job.
Yes.
And because they've been unemployed for so long, they just sign everything, anything that comes from it, because this is an opportunity presented to them. What would you tell people? What must they look out before they sign a contract, if a contract is presented to them?
Yeah. So, firstly, in order for there to be an employment relationship, definitely it's good to have a contract in place, but sometimes it happens that a contract is not signed yet, but the terms have been agreed to. So an employment relationship has already begun. It is there. But if there's a contract, the most important thing that a person should look at, if as a lawyer, I'll go to Section 29 of the Basic Conditions of Employment Act, which stipulates the general terms that have to be in an employment contract. Firstly, obviously, you need to look at your details as the employee and the employer's details, place of employment. And you also need to look at the job title and the job description. What will you be required to do? The times, when are you required to do the work that you are employed to do? And also look at the deductions from your salary. Salary is one of the issues that we come across as a problem when it comes to employment relationships. But make sure that you look at those things and don't sign a contract or enter into a contract that you are not satisfied with, because it becomes very difficult to renegotiate the contract once you've signed it, or to change the terms and conditions of that contract. But the most important thing is the job description. What is required of you?
So I want to pick up on two things here. Is the job description and what you're actually doing later on in the job, and then kind of can you renegotiate the contract. So
Yes.
Let's start with the renegotiation of contract. As an employee, after you sign this, let's say, a horrible contract,
Yeah.
is there in law a way for you to renegotiate your contract?
So, in terms of the law of contract, it's very difficult to vary the terms of a contract that's already entered into, because the big question is, were you induced into entering into the contract? And in most cases, the answer is no. So it's very difficult to renegotiate an employment contract. That's why I always advise people to first seek assistance if necessary before they enter into a contract. So the answer is, if both parties to the contract are willing or are of the same mind and want to renegotiate the contract, then that's fine. But if one party is not willing to do that, it's really difficult. And that would result in the employment, for example, because one will not be happy. The employment will have to come to an end. And perhaps at a later stage, a new contract will have to be entered into, and that's a new employment relationship coming into place.
So let's say I'm entering in this contract and someone told me I must do X.
Yes.
So it started off by doing X, but then they added Z, and then they added A. So on the contract description is like I'm only supposed to do X, but the responsibilities month, quarter after quarter, year after year just keep growing and growing. And I think that's a lot of frustration for people because you don't know how to deal with that situation. So from a legal perspective, how do an employee that is trapped in a kind of type of relationship like this, what options is open for them in a situation like that?
Okay. So firstly, I would not say that they are trapped, because when they enter into the contract, they can terminate the contract, obviously, with following the terms of that contract, with a notice period being served, etc. But the important thing is that when the job changes, there needs to be a discussion between the employer and the employee. So when the employee notices that the work that they are required to do is changing, then they need to start a discussion, a conversation with the employer, and ask questions as to, for example, they will say, I see that my job description is A, B, C, D, and now X, Y, Z is being added. Can you sit down and talk about that? And then obviously that will also include a discussion about the salary, or also the working times, the capacity, because in such instances, it would be an addition of work on top of more work that's already in existence. So the employer and the employee will have to look at the capacity of the employee to continue doing the work and take on further work. So my advice would be for there to be a discussion between the employer and the employee. And if the employer is not willing to have that conversation with the employee, then that's the terms of contract being varied, and the employee will have the right of recourse to go to the CCMA or a bargaining council and lodge an unfair labor practice dispute, because the employer will have now varied the terms of the contract at that point in time.
And I think that is where most employees are at in the South African kind of economy and labor system, is that their responsibilities just keep growing and growing. I remember I was in a case of unfair labor practice with the employer, and the relationship after that was so bad with the employer that it felt like I was not welcome there anymore. So now we entering to issues of what we call a constructive or unfair dismissal. Can you please speak to us a little bit through this? What's the difference? When is the constructive dismissal and when is the unfair dismissal?
So I'm going to explain it in simple terms. So I think I've already touched on unfair dismissal. So in unfair dismissal, it's when the employer dismisses an employee without concrete reasons for such dismissal, and or without following proper process prior to the dismissal. Proper process being that if there's a misconduct issue, it has to be dealt with appropriately, which is by holding a disciplinary inquiry where the employee gets the opportunity to state their case and the employer gets the same opportunity. And that will have to be before or in front of an impartial third party who will sit as a chairperson. So that's an unfair dismissal. Substance and process comes into play. And then a constructive dismissal, it is when basically an employer places an employee in a position where they are trying to force them to resign. And ultimately, the employee will actually resign and they will have a right of recourse at the CCMA or the bargaining council where they claim constructive dismissal. So in that instance, the employer or the conditions are made so intolerable that the employee can no longer continue working for that employer. So,
and you can explain it to just in a bit. You can't just resign and say it's a constructive dismissal. So what is the type of evidence that the employee needs to present to prove a case at the CCMA that this constitute to a constructive dismissal? Because I don't want people to listen to this podcast and then like, I don't list my job anymore, so I'm frustrated with this person, so
Yeah.
I'm going to resign. And then Zikhona said it's it's a constructive dismissal.
Okay, I'm just going to put this out there. I'm not saying people should resign as well because they are not happy at their jobs and then they're going to go claim a constructive dismissal at a later stage. It's very difficult to prove constructive dismissal because you need to prove to the commissioner at the CCMA that the working conditions were so intolerable. So intolerability is, we must underline that word. They were intolerable that you could no longer continue working for the employer. And proving that working conditions are intolerable is quite a challenge at the CCMA. It has to be in the extreme, extreme actions taken by the employer or for a person to succeed in proving constructive dismissal. So once again, it has to be intolerable. That's the bottom line.
And I think it must come from you telling people that anything in life, if they want a case, there needs to be evidence.
Definitely. That's why I always also advise clients that, not just clients, but people in general, when you are in an employment relationship and you think that there might be issues, having things in writing is very important. Because when you are challenging a dismissal, for example, you're going to have to provide evidence to the commissioner at the CCMA. You're going to have to provide evidence if the matter is before the labor court. So you need to ensure that you've got your ducks in a row. You need to ensure that you've got documentary evidence. You need to ensure that there's the contracts, there's the emails, or any other correspondence that was exchanged between yourself and the employer. And evidence is the only way that you will succeed in labor matters. Okay. Not the only way, but it's the most important.
Yeah, because people might know it in the institution, but if you don't have that evidence, and I know this for a fact because I was in a couple of these issues, and then people's cases were not heard because the evidence was not there, and then unfortunately you can't go any further.
That's true.
Apart from dismissals, there's also issues of discrimination.
Yes.
So, between the range of discrimination in South Africa, if we consider Section 9 of our Constitution, our great Constitution, which one would you say, gender, age, or race-related? Which one, or even religion?
Yeah.
Which one of those are most common in South African the labor spectrum?
Yeah, I just want to comment on something that you've said just now about our constitution, which is great, and I totally agree with you on that. You know, our laws on paper, they're great, and implementation, we need to improve on that. So Section 9 of the Constitution, I'm going to relate it to Section 6 of the Employment Equity Act, which speaks to discrimination that is not permissible in the workplace, basically. And that is sex, gender, race, and there's more, which is also listed in Section 9, as you've mentioned. In the cases that I've come across, the one form of discrimination that I have come across relates to age. And while speaking to you, there's one case that does come to mind where an employee was a grown man, but he was not at a retirement age, and you'd find that the employer would have meetings just to convince them to resign or take early retirement, and they were not ready to do that. And they were subsequently dismissed for something not related to the discussion, to those discussions. But when you look at the meetings and when you look at the discussions and the correspondences, you can clearly see that the issue of age was at play. So we contested that matter, and it was actually an unfair discrimination dispute based on age. So age is one of the factors that I've come across predominantly.
It's also something that I've noticed recently is that some employers doesn't want to employ people close to the retirement age. So if the person is like 60 or 59, then they have doubts, like this person is going to work a couple of years and then it's pension. Is that a form of discrimination based on?
Definitely, I'd say if that's a reason, that's the reason that a person is not employed if they were applying for a job, then that is a form of unfair discrimination, because Section 6 stipulates that we cannot discriminate based on age, race, sex, etc., etc. So definitely yes.
Because there is some people who take early retirement and then wants to get into the labor again, and then they have like 5 or 6 years left, and then but people say, but
yeah,
you're too old. We'll invest. We will have a much bigger investment on a younger person.
And you know what the problem is with that statement that you are too old? What is not considered is the experience that you come with into the labor market, and your ability to pass on that experience to the younger people that you'll meet in that employment. So I think it's short-sighted to say it's unfair discrimination, and definitely it's short-sighted to say that a person is too old. And especially if the person is qualified and has the necessary experience to do the work. As employers, I think you will have to think about the value that they will add to you, to the employment relationship, or to the work that they will be doing. And that's something that people don't think about.
So here's my question then. If there is discrimination based on age,
yes,
can you discriminate against the person when they're older than 65, the retirement issue, or does that still count for discrimination against race?
No, it doesn't, because they are retired already, so it would ordinarily not count.
Oh, okay. So up until 65. So you can discriminate after 65.
No, it's not It's not unfair discrimination. You need to also note that there's a difference between unfair discrimination and discrimination. So if it's discrimination that is not unfair, it's acceptable. An example that I'll make is when one employer is given a vehicle and the other one is not given a vehicle because of the type of work that these two employers do. You can't say that there's discrimination because one is given a vehicle and one is not, because you look at the job that they do. Is it necessary for the other one to get a vehicle? Not. So in the issue of age, it cannot be, if you are over the retirement age, it can't be unfair discrimination because you're already retired.
So ladies and gentlemen, this is an important distinction. So there's unfair discrimination and there's discrimination. So in the workplace, there can be discriminated. There is discrimination, and it's based on the job, the type of job that you're doing. And in my particular case, if you're older than 65, you can be discriminated against because the retirement age is 65, legally in South Africa. Am I right?
You're correct, but I just want to say that you need to distinguish between discrimination and unfair. If it's unfair, it's unwarranted, then it's not acceptable.
So unfair then would be 64, unfair discrimination, and discrimination would be 66.
Say that again.
So I just want to, for someone who's watching this,
yes,
as an employer, and they have someone who is 64 that is applying for a job.
Yes.
And then they reject that person based on age. That's unfair discrimination.
Yes.
But if the same employee was 66 and they then reject that person, then it's regarded as discrimination.
It is discrimination based on age, but it's not unfair discrimination.
So the only thing that counts in the South African labor law is unfair discrimination.
Definitely. Underline unfair.
Yeah, we go. So before I move off the topic of constructive or dismissals, is there a time period when it comes to constructive dismissals?
You know, I'm going to answer this question looking at dismissals in generals. When you're talking about referring constructive dismissal to the CCMA, for example. Yeah. So dismissals have to be referred within 30 days to the CCMA, and unfair labor practices 90 days. So there is a time period. And that's important to adhere to. And if you don't adhere to that time period, you will have to apply for condonation. And you'll have to provide good reasons why you are late, and whether you've got good prospects of success, and whether there'd be any prejudice if the matter continues. So 30 days is the cutoff time to refer a constructive dismissal or any form of dismissal.
So what if it's condemnation?
Condonation application.
Yeah. Is there a time period for that also, or can I 5 years later?
You find people that apply for condonation 5 years later, and if you look at that time period and if you look at the prejudice and prospects of success, you need to consider those factors. That's what commissioners need to consider. And if you are applying for condonation, you need to look at those factors as well. And people do apply for condonation years after they were supposed to lodge their claim. And in most instances, if so much time has lapsed, the condonation will not be granted. So again, I always advise people to lodge their disputes within the time frames. And if they don't, they need to know that it will be very difficult to succeed in a condonation application without good reasons provided.
All right, ladies and gentlemen, you hear it. Make sure that when you resign, if you're unhappy when you resigned, or if you're in a current situationship at work, that you know the time period. Once you know the time period, then you know what is open to you. But I also think people generally need to read up.
I definitely agree with that. And one other thing, people need to know these time periods. They need to seek advice. I think that's the most important thing. Because sometimes they might read and interpret what is written differently. But if they were to get assistance from a qualified person with a legal background or who knows labor laws and would be able to assist them, that would be of great value, you know.
And that is what I wanted to come to. If you have to choose, so what you say then is, if before you go to, there's a thing like Dr. Google where you Google your symptoms. So when you go, before you go to a lawyer Google, after you consult a lawyer Google, seek legal representation. Your best chances is with legal representation. Am I right?
Correct. That's absolutely correct. And the other reason is that the law changes, all the time, and we've got case law that has an impact on the law all the time. So if you're going to read something on Google, it might be outdated. So that's why you're going to need to get legal advice.
All right, thank you. So my final question is, this one is for the internet, ladies and gentlemen. This is not my words. This comes from Zikhona's words. Look at the labor and the payment situation in South Africa. Would you say black people in South Africa? When I say black, then I mean African black. I'm not including colors. I'm not including Indians in that. I'm meaning African black. South Africans, are they getting paid enough of fair wages in South Africa?
And I'm going to answer that question this way. More research needs to be done when it comes to that. I cannot say yes or no and be absolutely certain when answering that question. We need to conduct research to be able to answer that.
So, and I'm glad you're mentioning research. Do you think that employers will give us the data? Because I think that is the biggest issue, is that the access to data and especially employment statistics is so hard to come by. Do you think there needs to be a law or something that needs to be passed, or is there something in place that kind of instruct employees and organizations that employing people to give their statistics?
The first thing that springs to my mind is the information regulator, how information is regulated. But without going into details, You know, we've had sayings that when you get employed, you're not allowed to disclose your remuneration and so forth. And the big question is, why is that? So whether we would get the stats or the information from employers, I think that would be very tricky. That would be very tricky. And I cannot say for certain whether we would get that information if research were to be conducted or not. So I think even before research, one would have to assess whether getting that info would be possible or not. And if not, the question would be why? Why not?
So just finally, before I conclude, is that where does the Department of Labor fit in this particular situation? Because in this specific instance, when it comes to data and labor statistics, aren't they supposed to be the watchdog of South Africa to make sure that labor issues, even when it comes to the stats, that they are the kind of central place where you get this information from?
One would expect that to happen, but the labor market is very wide. And, you know, with departments, certain things just slip through the cracks. So, again, I don't have the answer to that question, a direct answer to that question.
All right. Zikhona, thank you very much. That is such a lawyer answer. I was really hoping that I got a clickbait for YouTube, clickbait. She said it, but she didn't say it, ladies and gentlemen. More research needs to be conducted. So if there's a PhD student or master student out there, I think that's a brilliant topic for PhD or masters to do that, to conduct research on that specific area. So thank you for highlighting that there needs to be more research. Zikhona, thank you very much for joining me and having this beautiful conversations. And ladies and gentlemen, before I say final, there's going to be more between me and Zikhona. So there's a lot of things in the labor market that we have to that we can unpack. So the one section just on the CCMA, the process. People need to know the whole process, disciplinary issues, trade union issues. So there's many more of these sessions between me and Zikhona coming. So I hope you guys find the magnificent benefit that I got from this particular episode. And with that, I want to thank you. Zikhona.
Thank you so much. Thank you, Jacob. And I'm also looking forward to the more episodes that we'll have in the future.
All right, thank you. Bye-bye.